Assalamualaikum warahmatullahi wabarakatuh and hi everyone. My name is Mustafa bin Muhammad Qasim, and in this video, I will be presenting an industrial relation case analysis for the course INC500, Industrial Relation and Cybersecurity, which is taught by Professor Madya Dr. Shahnawi. The case that I will be discussing is Muhammad Fauzi bin Muhammad Shariff versus Bank Islam Malaysia Bhd, a decision by the Penang Industrial Court Award number 25 on 2025. This case is interesting because it shows that not every proven misconduct automatically justify dismissal, especially when the court looks at fairness and proportionality under Section 20 of the Industrial Relations Act 1967. Before we start, let me share a little bit introductions. Around the second quarter of 2025, several media platforms began sharing a case involving the dismissal of an employee from Bank Islam Malaysia Bhd. The industrial court's decision quickly drew attention not only from the media, but also from industrial relations practitioners as well as HR professionals who actively discussed the outcome and its implications. So, what were the actual facts of the case? And what issues did the industrial court consider before arriving at its decisions? To understand why this case attracts so much attention, it is important to first look at the fact behind the dismissal. The claimant, Muhammad Fauzi bin Muhammad Sharif, joined Bank Islam Malaysia Berhad on 6 October 2010. He began his employment as a manager at the Bayan Baru branch in Penang, and in 2020, he was transferred to the Alor branch as a branch manager. At the time of his dismissal, his last drawn salary was RM 50,052 ringgit, with an additional allowance of RM 862 ringgit and 55 cents per month. On 3rd November 2021, the bank issued a show cause letter alleging two matters. First, the failure to ensure compliance with the bank's COVID-19 Standard Operating Procedure (SOP), and the second, sleeping at the workplace on 11 occasions between October 2020 and April 2021. The claimant denied sleeping at work and explained that his condition was health-related. Moving on to the disciplinary process, the bank then initiated a domestic inquiry or DI. The DI was conducted on 21st December 2021. However, it is important to note that inquiry proceeded only on the charge of sleeping at the workplace, while the allegation relating to non-compliance with COVID-19 SOP was not pursued. Following the DI, the claimant was found guilty of the charge of sleeping at the workplace. As a result, he was dismissed with immediate effect on 11 January 2022. The claimant subsequently referred the matter to the Industrial Court under Section 20 of the Industrial Relations Act 1967, alleging that his dismissal was without just cause or excuse. So, after reviewing the facts, the Industrial Court identified several key issues that required careful consideration before deciding whether the dismissal was fair. The first issue was whether the claimant had committed the alleged misconduct of sleeping at the workplace, as claimed by the bank. This required the court to examine the evidence presented by the employer and determine whether the misconduct was proven on a balance of probabilities. The second issue was whether the dismissal was carried out with just cause or excuse under Section 20 of the Industrial Relations Act. Here, the court had to assess not only whether misconduct exists, but also whether the employer was justified in terminating the employment relationship. And the third issue concerned the proportionality of punishment. Even if misconduct and just cause were established, the court still need to consider whether dismissal was a proportionate response, taking into account mitigating factors such as the claimant's length of service, work records, and the surrounding circumstances of the misconduct. This issue formed the legal framework that guide the court's reasoning and final decisions in this case. So, we go to the judgment of the case. After considering the facts and issue before it, the industrial court then delivered its decision on the claimant's dismissal. The court first held that the misconduct of sleeping at the workplace was proven. This is based on the evidence present, including photograph, witness testimony, and the claimant's own admission that he had briefly fallen asleep. The court was satisfied that the bank had discharged its burden of proof on a balance of probabilities. However, the court made an important distinction between proving misconduct and justifying dismissal. Although the misconduct was established, the court emphasized that not every proven misconduct automatically warrants dismissal. In assessing whether the dismissal was carried out with just cause or excuse under the Section 20 of the Industrial Relations Act, the court took into account several mitigating factors. This included the claimant's long length of service, his generally good work records, and the fact that this was not a case involving dishonesty or financial loss. The court further held that the punishment of dismissal was disproportionate to the nature of the misconduct. Dismissal, being the most severe form of punishment in employment law, was found to be too harsh in the circumstances of this case. As for remedies, the court decided that reinstatement was not appropriate given the breakdown of the employment relationship and the claimant's impending retirement. Instead, the court awarded monetary compensations. However, recognizing that the claimant had contributed to the situation through his own misconduct, the court applied a 50% deduction to the compensations award. As a result, the final amount of compensation awarded to the claimant was Ringgit Malaysia 240,348 ringgit, payable by the bank within 30 days from the date of the award. Okay, so we go to the analysis and critique part. In analyzing the issue of misconduct, the industrial courts found that the bank successfully proven the allegation of sleeping at the workplace on a balance of probabilities. This approach is consistent with the established. This approach is consistent with established industrial relation principles where the burden of proof lies on the employer, as recognized in Samirah Lee versus Freescale Semiconductor Malaysia Bhd case. In that case, the court emphasized that an employer must clearly prove misconduct before disciplinary action can be justified. In the present case, the court relied on photographic evidence, witness testimony, and the claimant's own admissions that he has briefly fallen asleep during working hours. Taken together, this evidence was sufficient to establish the existence of misconduct. However, the court was carefully to draw a clear distinction between proving misconduct and justifying dismissal. Although the misconduct was proven, the court did not treat this finding as automatically justifying termination of employment. From an analytical perspective, the court could have further explained how the claimant's health-related explanation was weighed when assessing the seriousness of the misconduct. A clear discussion on whether the conduct was intentional or momentary could have strengthened the reasoning at this stage. That said, the court's approach reflects a balanced and principles application of industrial relations law, ensuring that disciplinary findings are supported by evidence while still preserving the broader requirement of fairness. Okay, moving on the issue of just cause or excuse, the court emphasized that its role under Section 20 of the Industrial Relations Act is not limited to confirming whether misconduct occurred. This approach reflects the well-established principle in Gun Kui Poi versus JNP Codes Malaysia Bhd, where the court held that the industrial court must examine the fairness of the dismissal as a whole, rather than merely acting on appellate body to the employer's decision. In applying this principle, the court considered several mitigating factors in favor of the claimant. Although the claimant held a senior position as a branch manager, the court found that these mitigating factors outweighed the seriousness of the misconduct in determining whether dismissal was justified. From a critical perspective, one may argue that the court could have given greater weight to the claimant's managerial responsibility, as senior employees are often expected to set an example for their subordinates. However, the court reasonings demonstrate a consistent application of Section 20, reinforcing the principle that even proven misconduct does not automatically amount to just cause or excuse for dismissal. Okay, turning on the issue of proportionality of punishment. The court examined whether dismissal was an appropriate response to misconduct that has been proven. In doing so, the court adopt the established principle that dismissal is the most severe form of punishment in industrial relation, often described as the capital punishment of employment law. This principle was articulated in Goodyear Malaysia Bhd versus National Union of Employee, where the court emphasized that dismissal should only be imposed in case of serious misconduct that fundamentally undermine the employment's relationship. Applying this approach, the court found that although the claimant had committed misconduct, the act of sleeping at the workplace did not justify the ultimate penalty of dismissal, especially when viewed against his long service and overall employment records. Okay. The court also considered that lesser form of disciplinary action, such as warnings, suspension, or demotions, could have been imposed instead of dismissal. From a critical perspective, one could argue that the court's approach reflects a strong employee protective stance, which may raise concerns among employers about maintaining workplace discipline. And at the same time, the decision reinforced the importance of graduate and proportionate disciplinary measures, ensuring that punishment is fair and commensurate with the nature of misconduct. And the fourth analysis and critique, moving on the issue of the domestic inquiry, the court clarifies that proceedings before the industrial courts are conducted de novo, meaning the court hears the matters afresh and is not bound by the finding of the inquiry. This principle is well established in Dreamland Corporation Malaysia Bhd versus Chung Chin Soy, where the court held that defects or limitation in a domestic inquiry do not automatically invalidate a dismissal. In this case, although the domestic inquiries proceed only on the charge of sleeping at the workplace, The industrial courts independently assess the evidence presented by both parties. From an analytical perspective, this approach ensures that decisions are based on substantive fairness rather than purely on procedural technicalities. However, from a critical standpoint, employers should not treat the de novo principle as a license to conduct domestic casually. A poorly conducted inquiry may still weaken the employer's case before the industrial courts. So, overall, the court's reliance on the de novo principle strike a balance between procedural flexibility and the need to uphold fairness in disciplinary proceeding. Finally, the court considered the appropriate remedy and compensations to be awarded to the claimant. In this case, the court decided that reinstatement was not appropriate, taking into account the breakdown of the employment relationship and the practical realities surrounding the claimant's positions. Instead, the court awards monetary compensation, but significantly applied to a 50% deduction to reflect the claimant's own contribution to the misconduct. This approach is consistent with the principle recognized in 711 Malaysia Bhd versus H1 Hari Krishnan, where the court held that compensations may be reduced the amount for contributory misconduct by the employee. From an analytical perspective, this method allows the court to strike a balance between protecting employees from unfair dismissal and recognizing an employer's right to discipline misconduct. And from a critical standpoint, while the reductions may appear substantial, it reinforces the message that employee cannot be completely absolved of responsibility where misconduct is proven. Overall, the remedy granted reflects a balanced and pragmatic outcome, ensuring fairness to both parties rather than favoring one side entirely. So, in summary, this case confirmed that proven misconduct does not automatically justify dismissal. The industrial courts emphasize fairness, professionality, and appropriate remedies under Section 20 of the Industrial Relations Act 1967. The court reasoning was supported by established industrial relations authorities, and the following uh, reference cases are listed as reference to the main cause. And with that, thank you from me.